distinguished professors, distinguished research scholars, students, and their colleagues. Good afternoon and good morning, and welcome to this important and timely international webinar on the right of self-defense under international law, principles, practices, and prospects. It is a privilege to address such distinguished audience on the subject that lies at the heart of contemporary international law, one that not only shaped the behavior of the states, but also define moral and legal boundaries of sovereignty and security in the complex world. In recent years, international community has found itself grappling with the resurgence of armed conflict that spans the globe. From Russia wars against Ukraine to the protracted violence between Israel and Palestine, to the tension involving between Israel and Lebanon, and the deadly terror attack in Kashmir, the conflict between India and Pakistan, and finally the fraught relationship between the United States and Iran. These conflicts, while geographically varied, share a common traits. The question is when and how a state may lawfully exercise the right of self-defense. At the core of this debate stands the United Nations Charter, which enshrines the principle of prohibition and use of force under Article 2+4, while simultaneously recognizing in Article 51 the inherent right of self-defense if an armed attack occurs. Yet, interpretation of these provisions has become increasingly contentious. What constitutes an armed attack? Under what circumstances may anticipatory, preemptive, or collective self-defense be invoked? How does international law navigate the murky waters between the legitimate defense and the unlawful aggression? Furthermore, our world continues to evolve new challenges such as cyber attack, weaponization of artificial intelligence, and use of drone strike cross borders. These developments have introduced a new dimension to the practices of self-defense. And now the question is, can traditional legal principle crafted in mid-20th century adequately address the complexity of the 21st century, that what we face with the warfare? Our discussion lies on the exploration, and the question will be discussed by our esteemed speakers. It is with the great pleasure now I introduce our exceptional lineup of the speakers. To begin with today's program, we are honored and privileged to have with us our esteemed chief guest, esteemed Professor Manoj Kumar Sinha, Honorable Vice Chancellor of Dharmashastra National Law University, Jabalpur, and it is followed by Professor David Ambrose, guest of honor, Professor of Law at Madras Legal Studies, and sir is right now working as a research officer at the Government of Tamil Nadu. And it is followed by Professor Shri Nawaslo, Professor of National Law University, Juridical Science, and Professor Kenneth Wayan Mutamma, Professor of Law at Mountain Kent University, Kenya, and Professor Mirza Asmir Bek, and Professor Banerjee Chaka, and followed by a young researcher and author, Dr. Atul Alexander, Assistant Professor of Law at the West Bengal National Law University of Juridical Science. And I would like to also introduce the organizing secretary, Professor M.S. Benjamin, Dean Professor of Law at Department of Studies, Law and University of Mysore. To begin with today's webinar, I would like to request Professor M.S. Benjamin to welcome the esteemed speakers to today's program. Sir, over to you.
Thank you, Mr. Kudrat, Syed Kudrat, distinguished guest, Honorable Vice Chancellor, Professor Manoj Kumar Sinha, Professor David Ambrose, Professor N.S. Srinivasulu, Professor Banerjee Chaka, Professor Kenneth Wayan Mutamma, Professor Mirza Asmir Bek, Dr. Atul Alexander, respected faculty members, scholars, practitioners, students, and dear participants. It is indeed my privilege to welcome you all to this international webinar on the right of self-defense under international law, principles, practices, and prospects, conducted by the Department of Law, University of Mysore, Mysore, Karnataka, India. The subject which we discuss today is one of the most complex issues in the realm of international law. Article 51 of the Charter of United Nations provides that it's the inherent right of self-defense of a state to protect its people, territory, and resources against armed attack. It also plays a very significant role in maintaining international peace and security among states. Before proceed to welcome the dignitaries, let me take a 2 minutes to explain the concept of a right of self-defense. The right of self-defense is based on customary international law and the Charter of the United Nations. Its genesis can be traced in a famous case of Caroline of 1837, wherein the court laid down various parameters for the lawful exercise of self-defense by states. The Covenant of the League of Nations implicitly recognizes the right of self-defense for its member states. The General Treaty for the Renunciation of War, Kellogg-Briand Pact 1928, also permits military action in self-defense. Article 51 of the Charter recognizes the right of self-defense as an exception to the general rule that prohibits the use of force. According to the provisions of the Charter and the rulings of the International Court of Justice, there are some principles about right of self-defense. Firstly, the precondition for the exercise of right of self-defense is that a state must be under armed attack by another state. Secondly, self-defense must be exercised and declared by the state injured by armed state. Thirdly, the right has to be necessary and proportional to the degree of attack. In other words, this right has to be exercised to curb other states' attack and achieve the purpose of protecting national security and its people. Fourthly, the injured state has a right of self-defense until the Security Council that takes measures necessary to maintain the international peace and security. However, with the rapid advancement of technology, economy, and politics, the right of self-defense faces new challenges and has become complex and controversial. The contents of a right of self-defense somewhat ambiguous. The terms like collective self-defense, anti-terrorism self-defense, preventive self-defense are susceptible of various interpretation. In the present Russia-Ukraine conflict, Ukraine is still fighting for reclaiming its territory from Russia. Ukraine is unable to exercise the right of self-defense as contemplated by Article 51 of the Charter. The interim order passed by the ICJ is still not implemented by the Security Council of United Nations. In Israel and Gaza conflict, Israel launched an attack on Jordan, Lebanon, and Syria, but no condemnation from the international authorities. Iran was not able to defend itself when airstrike was launched by America and Israel. This webinar stimulates rigorous legal debate on the doctrinal foundations, state practices, contemporary challenges surrounding the right of self-defense, and also contributes to the development of constructive perspectives that promote international peace and security. On behalf of the Department of Law, University of Mysore, the Mysore, Karnataka, I extend a warm welcome to all dignitaries. The chief guest of the program, Professor Dr. Manoj Kumar Sinha, Honorable Vice Chancellor, Dharmasastra National Law University, Jabalpur, the Madhya Pradesh. Guest of honor, Professor Dr. David Ambrose, former Chairman of the Department of Legal Studies, Dean, Faculty of Law, Madras University, Tamil Nadu. Keynote speakers, Professor Dr. Srinivasula N.S., Professor of Law, National University of Juridical Sciences, Kolkata, West Bengal. Professor Dr. Banerjee Chaka, Dean, VIT AP School of Law, Andhra Pradesh University, Andhra Pradesh. Distinguished speakers, Dr. Kenneth Wine Kutuma, Professor of Law, the School of Law, Mount Kenya University, Kenya. Professor Dr. Mirza Hasmer Beg, Professor, Department of Political Science, Aligarh Muslim University, Aligarh, Uttar Pradesh. Dr. Atul Alexander, Assistant Professor of Law, National University of Juridical Sciences, Kolkata, West Bengal. I also welcome all participants, members of the organizing committee, our coordinator, Mr. Syed Kudrat. I wish this seminar will be thought-provoking, engaging, and fruitful. I once again welcome you all to this webinar. Thank you all.
Thank you, sir. To begin with this session, I now invite our co-host, Ms. Sarah Benjamin, to introduce Professor Manoj Kumar Sinha, sir. Then sir will begin with his insights to the talk. Yes, sir.
Good afternoon, respected dignitaries, esteemed colleagues, faculty members, students, and distinguished participants. It is indeed my proud privilege to introduce our chief guest for today's occasion, Professor Dr. Manoj Kumar Sinha, the Honorable Vice Chancellor of Dharma Shastra National Law University, Jabalpur, Madhya Pradesh, India. Professor Sinha is a distinguished legal academic, administrator, and scholar of international repute. Prior to taking charge as Vice Chancellor of Dharmashastra National Law University, he served as the Director for the Indian Law Institute, New Delhi, and has also had leadership positions at the Indian Society of International Law as its Director, besides serving as Secretary of All India Law Teachers Congress. He has also taught as Professor of Law at the West Bengal National University of Juridical Sciences, Kolkata. He holds a doctorate in international law from Jawaharlal Nehru University, an NLM from the University of Nottingham, UK, and an LLB from the University of Delhi. His areas of expertise include human rights, constitutional law, international humanitarian and refugee law, international criminal law, and international institutions. Professor Sinha has authored and edited several influential books such as Perspectives on Indian Constitution and Development, International Criminal Law, and Human Rights of Vulnerable Groups. His writings are widely cited, shaping both academic debate and policy development in India and abroad. His international recognition is equally impressive. He has delivered lectures at prestigious European universities as a visiting professor and has been invited by the ICRC, the Ministry of External Affairs, and the Ministry of Environment and Forests to contribute his expertise. In 2009, he received a scholarship from the International Development Research Center, Canada, for his outstanding contribution as a young scholar of international law. For his distinguished service, Professor Sinha has been honored with awards such as the Great Indian Teachers Award at the Lead Global Conclave 2021 and recognition as one of the nation's notable bar leaders by the Bar Association of India. His life's works reflects a rare combination of scholarly excellence, practical engagement, and commitment to advancing justice. We are truly fortunate to have him with us today. His presence not only adds immense value to this occasion, but also serves as an inspiration for all of us committed to law, justice, and nation building. Please join me in extending a very warm welcome to Professor Dr. Manoj Kumar Sinha, our chief guest of this gathering. Thank you.
Thank you, sir.
Thank you very much, Sarah, and respected Professor Benjamin sir and his team, respected Professor Dr. David Ambrose, and my colleagues from West Bengal National University of Juridical Sciences, and all the colleagues, students who joined this program online. It's a very the nicely both Professor Benjamin and young scholar they have already touched upon the important aspect of the right to self-defense and highlighted the present cases, important cases which were going. If we start looking into the law side and practice, so in fact, right to self-defense principles, there is no doubt about the principles. It's a well like outline under the international law, what I mean under the international United Nations Charter. But when we come to the practice, we find there is a huge gap. What has been stated in the Constitution, what has been mentioned under the United Nations Charter, and the practice is entirely contrary to there. So this is a huge challenge. Whether the power which has been given under the Article 51 of the Charter is is followed by the state which resort to the right to self-defense, and right to self-defense is indefinite, it's open-ended, or it's very limited. These are the questions we have in the genuine cases of the right to self-defense in one hand. On the other, what we have been seeing, the cases which you have been cited, and I'm sure the all speakers will cite in discussion, Russia and Ukraine crisis, Israel, Gaza, Iran attack on the Iran, and cases you can list number of cases. Total disregard to the principles, concept of international law at large, and that has become because I give you an example. Like we under international, there are 2-3 points which we need to ponder over. Whether the state should exercise the right to self-defense, or states should adhere more to the two important principles, purposes of the United Nations Charter. Professor Benjamin, you highlighted Article 2, Paragraph 4, Article 51, which gives, if you read in conjunction with the Article 2, Paragraph 4, Article 51, you find there's a scope of right to self-defense. But when and how right to self-defense has to be resorted by the state, that is an important question. And that raises the concern about the legality and illegality of the concept of right to self-defense in general. The solution to all these crises, if states, 193 member states, respect the charter principles, charter provisions, and particularly if believe in the first purposes, Article 1, Paragraph 1 and Article 1, Paragraph 2. If the state takes note of these two articles, we don't need to go into 2, 4, and 51. If it's the Article 1 paragraph, the purpose, the very first purposes, there are 4 purposes of the charter. We are talking about the principle. The first purpose is very clearly, the very first article of the charter, Article 1, Paragraph 1, it says to maintain international peace and security. It starts with, and to the end, to take effective collective measures for the prevention and removal of threat to peace, breach of the peace, or act of aggression. So it says to maintain, it's like the task has been given to the United Nations. Even the Article 51, which says, till the matter is referred to comes to the knowledge of the Secretary General, Security Council, or any way by the state, the right to self-defense cease to exist. Means right to self, in today's time, right to self exercising in true spirit of the charter is very difficult. But in the, because technologically the information can immediately what is happening in the other parts of the world. But adherence to the principles of the charter or articles of the charter has a big challenge for the international community at large. When we look into the international humanitarian law context, there are the concept of just war, and that just war, like it prevailed in for many years. When just war we take just at bellum and just in bello. Is at bellum and is in bello. When we talk about this at bellum, it talks about the war. Basically, it talks about the law on the use of force, and it basically focuses on the just war. But the concept of war is more or less settled and gone. So war is no longer, war is as a war as a term is prohibited under international law by the Kellogg-Briand Pact of 1928, the General Act of Renunciation of the War, which was actually signed by France and the United States in 1928. The renunciation of war in 1928, which subsequently there are 63 states ratified that Kellogg-Briand Pact of 1928, including Germany and Japan and many other countries. So the renunciation of war means any kind of attack or any kind of conflict. It's like in 1928. Germany also ratified that particular renunciation, this Kellogg-Briand Pact. But what we have seen after 10 years, we have Second World War in a new paper. So the term war is being prohibited under international law. And that is why international humanitarian law uses not the term war, it uses the conflict. It talks about the conflict so war as such is not there. But we have instances of two. So in colloquial way or like in a reference way, we use the term war under the international law, which is prohibited in 1928. And we have two classic cases where the cases of aggression or liberation of Kuwait was taken place during the first Gulf War and second Gulf War. There are two Gulf Wars, so more. So in the first Gulf War, it was authorized by the Security Council of the United Nations, and the Security Council at present till date, the Joint Military Staff Committee, which has been part of the Chapter 7, never came into existence. So in case of the first Gulf War, it was United States was authorized to liberate Kuwait. So there are 36 or 37 countries contributed their force and they liberated Kuwait from the Iraq. So that was legitimate some way. That is so power based with the Security Council. But in the second Gulf War, which is very interesting, when the right to self-defense can go in a different way, the determination. So both father and son in the first Gulf War, the senior Bush was there, and in second Gulf War, junior Bush was there as a president of the United States. So what the junior Bush accomplished the task to eliminate Saddam Hussein on the very, very fictitious ground, which subsequently it has been found that there was no weapons of mass destruction in Iraq. But the attempt of the United States to enter in the Iraq in 2003 was so strong. They said, no, because there's a threat. Iraq possesses weapons of mass destruction, and it will cause huge damage to the life and security of the international security for the neighboring states and even threat to the United States. So the best course of action when as a law teacher, a law students we talk about, it is the root of the Security Council of the United Nations. But in the second Gulf War, United States, George Bush had something different in mind, had something indifferent in mind. They wanted to complete the task which they some way they failed to complete in the first war, elimination of Saddam Hussein. That was the background. And what they have done, they have tried. Interestingly, the initial effort was seek the authorization from the Security Council of the United Nations. Professor Ambrose will also agree with me, and that was the first time a Western power, France, has openly opposed any attempt to send the forces with the help of the Security Council will be blocked by the France. France threatened for the veto. So finally, that they determined with Security Council or without Security Council, with UN or without UN, we are going ahead to enter in the Iraq. So the self-defense ground was become, the concept of self-defense was enlarged so huge. These two big power, United States and United Kingdom. And it's very interesting. If you look into the development in 2003, Tony Blair was the Prime Minister of the United Kingdom. And what he said that the functioning of the Security Council is more based on the political considerations. So he highlighted, it's not functioning in objectively, it's more political consideration. So we don't believe the functioning of the Security Council and we decide to go there. So you see the states which played very important role in the creation of the United Nations as such in 1945, they themselves are not in a position to respect. They have additional power, they have a veto power, they have some important position under the United Nations, but they are like free to violate. Now I'm surprised and shocked, and same I believe with the sir also, Amrut said, we hardly hear anything from the Secretary General of the United Nations. We keep on hearing every day who manages the conflicts in present situation of whether United Nations or whether United States of America. The current Prime President of the United States, he keeps on saying, even yesterday, I have stopped 7 wars, and he kept on counting the sum of the wars. We have no idea, but he has a list of the wars. He keep on saying that is there, 7. And he has developed a tactics. He says trade tactics. He's not diplomacy. He said he will not do trade with you, and that is the reason he keeps on keeps on. Just a second. हाँ जी अ- हाँ हाँ ठीक है ठीक बस ठीक. So he continues like so we see the role of the Security Council. So you highlighted Article 2 paragraph 4, you highlighted Article 51, both speakers have highlighted Article 2, and many will do that. But the spirit of article, the essence of Article 2 paragraph 4 and 51 are rarely adhered. The cases, like all the contemporary crises, there's a huge crisis in the challenge of, particularly in particular in this contemporary time. So we see it's the international law, international relations, everything like in the hand of one big power. We had some inkling. We thought when the demise of former USSR. So ideological differences which existed from the 1949 to 1989, after the end of the collapse of the USSR, we thought that the new world will come and world will be there. It functions multipolar for some way, where people will work with the spirit of the United Nations Charter. But what we see that after some time, things have started changing. It has started changing, and now in the 2025, I consider that some of in case of Obama, Biden, they were very much concerned about going lawful routes, legitimizing their action. But when it comes to the in today's context, we see something different, and that is the huge challenge. Nobody speaks about the Israel. Nobody can dare to speak, and even they speak, it doesn't matter. For the Israel, Israel not concerned about they decide. They have also given it's a right to self defense. Our defense is there, our security is in danger, and to end that danger, so they've forgotten the principle of proportionality. One attack has taken place on these 1200, and what is the cost they are paying? More than 70,000 people have been killed, and every day, just only for one incident of that's a disturbing incident. I'll not say that's not very but it was not for the action subsequently by the Israel is not proportionate to what Israel suffered on the 7th October. It says the entire city has become a ghost city, and neither United Security Council of the United Nations or Secretary General of the United Nations are in a position to do anything regard this particular. So this is the threat. This is the huge challenges. Principles are there, concepts are there, which you have highlighted, sir will highlight. So I think the first part we said, the very first purpose is Article 1, Paragraph 1, which I've said, that is important. Is international community must move the peace settling of their dispute on the peaceful way. there is no need of asserting the right to self. So when to start, when a state should exercise the right to self-defense, that is a question which is very vague and which has not found a settled answer. It has not reached on the penalty. It has not reached on the there. So preventive self-defense. The like so you attack because you have a fear that something will happen, or it should be an actual armed attack when you have been attacked. In 1971, it's like the Indian government in the War of Independence. India was a little bit in a dilemma and what to do. When we entered, we had a huge humanitarian crisis in 1970 war. But subsequently, Indian government, because our entry in the war was more on the ground of right to self-defense, and we justified. We did not use humanitarian crisis, though initial uh, thinking or initial approach was more related to the humanitarian crisis, humanitarian catastrophe. That was the main important aspect was there in 1971. So we entered in the right to self-defense. We can also pose a question this subsequently in the targeted intervention, targeted use, like what we have been using. So now the concept of right to self-defense in the conventional sense is no longer there. You can penetrate, you can go deeper in the another country without sending any forces. And we have said technology, artificial intelligence, uh, automated weapon systems. There are a lot of developments there where we see the traditional notion right to self, conventional army crossing international border. So new challenges are emerging. The concept of so we said we have a right to defend ourselves if we being attacked, even terrorist attack. We go inside and we demolish. So the selected, targeted right to self-defense, and that's important. And then we come back and say, no, we have not caused any harm. So there are a lot of gray areas where exercising of right to self-defense, and particularly in modern time, start off war of terrorism in case of after in 2000 where twin towers were attacked, and then United States, either you are this side or that side, and they intervened and in Afghanistan. So you see a lot of perceptional shift, paradigm shift we see when we come to the there. So my understanding and my suggestions, we must look into the two purposes of the United Nations. So what is the way out, where we have to go? So I say, no, we need to discuss the two paragraph 4 and 5, but we must follow the purposes of the charter, as I said, article paragraph 1, which give if there is a threat, this Security Council should come into picture and play the role. And the second, what I say is that article 1 paragraph 2, article 1 paragraph 2 is equally important. One is important, 1 to 2 is there. It talks about in year 1945, after the end of the war, Second World War, it says to develop friendly relations. Article 1 of the purposes of the United Nations to develop member states articles must work towards to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples, and to take other appropriate measures to achieve universal peace. So spirit of the article 1 paragraph 1, spirit of the article 1 paragraph 2 will help us to move for the establishing universal peace. If if I read article 2 paragraph when I go in the class, or anyone scholars who goes in the class and teach the article 2 paragraph 4, I believe some of you also mentioned it has acquired the status of just cogence under the international law. But when you read Article 2 paragraph, when you teach Article 2 paragraph in isolation, independent of Article 51, it gives a different interpretation. It's like reading the Part 3 of the Constitution independent of Part 18 of the Constitution. If you read Part 3, fundamental rights appears to be very strong. But if you read fundamental rights along with the emergency provisions from Article 350 to 360, then you find there is a limit to the fundamental rights from other. There are reasonable restrictions exist under the fundamental rights, but 352 gives more power to the state to deal with extraordinary situations. So clubbing this understanding of the fundamental rights and emerging provisions. Same way I'm saying Article 2, paragraph 4, if I speak on, I say ki use of force is prohibited against the territorial integrity and political independence of sovereign states. Even I don't see anything in Article 2, paragraph 4, which talks about right to self-defense. But when we go into the much later part, and then we look into Article 51 of the Article Article 51, which gives you a right to self-defense. So reading in, so that is the important, and I'm very happy that Sir Benjamin, sir, you highlighted also Article 2, paragraph 4 in conjunction with the Article 51. Means Article 2, paragraph 4 is not an absolute. It has some limitations imposed under the Article 51. But we have to also remember states are exercising, states are violating the fundamental principles of proportionality, fundamental principles of, like, they, for a small attack, you can't finish the entire state. So you can't occupy the territory. So what happened in Gaza or this in Israel, it doesn't permit Israel to completely demolish the country. So it also violates the principle of humanity, principle of proportionality, principle of distinction also, which is very much apparent. The instances are going on that particular. So to close what we see, whether right to self-defense, states should exercise when actual armed attack takes place. Actual armed attack, not only future speculation, hunch, or fear. कि armed attack will be. So armed attack should, if actual necessity, whether it's a necessity for the armed attack, whether the right to self to exercise is there, and whether it also, so right to self-defense states are also in using in case of the non-military threats. Non-military threats can also, and as you some also, you have resurgence of armed conflict which are happening. So a careful understanding what we have to teach. We are passing through a phase which is full of challenges, full of difficulties to maintain international peace and security. I have seen, and many of you have seen on the site of the United Nations, that more than 80 to 90 places you have non-international armed conflict is happening. So I see there are challenges, which we have immense challenges. The concept, I see that any teaching, any understanding, it has to start from the purposes of the United Nations Charter and then go to the principles of the Charter and then you go to the article. So for me, if right to self-defense exists and allow permitted under the Charter, it intended for the limited exercise and it has to be used for the purposes which it intend, not for the completely was out. I hope that future, we don't know how future where we'll go, that things will more improve, where is and application of Article 51 will be rare and then very exceptional. With this, I would like to thank the organizer and Professor Benjamin, and of course, Professor, always good to speak in before the Professor Ambrose sir. And so thank you very much for all of you. Thank you very much.
Thank you.
Professor Sinha, for your insightful and engaging address. We shall move. Next, I would like to invite Ms. Sarah Benjamin to introduce our guest of honor, Professor David Ambrose, and sir will begin with his insight. Yes, Ms. Sarah.
Today, we are honored to host a truly eminent figure in Indian legal academia, Professor Dr. David Ambrose, former professor and head of the Department of Legal Studies at University of Madras, Chennai. With a PhD and decades of teaching experience, Professor Ambrose has been a guiding light in the domains of public international law, private international law, conflict of laws, constitutional law, environmental law, human rights law, and cyber law, and intellectual property rights. His vast range of scholarly engagement reflects both his depth and breadth in legal studies. During his distinguished tenure as the head of the Department of Legal Studies, beginning in April 2013, he stayed on one of India's oldest law faculties towards greater academic excellence and innovation. His leadership fostered interdisciplinary research, enhanced student mentorship, and strengthened ties between law and society through curricular and extracurricular initiatives. Beyond formal roles, Professor Ambrose has actively contributed to the legal community through memberships in esteemed professional bodies. These include the Madras High Court Advocate Association, Madras Bar Association, the Comparative Law Academy Pondicherry, and the Indian Institute of International Law, New Delhi. As a life member in several of these associations, he has played an ongoing role in bridging the worlds of academia, practice, and policy. His insights span the evolving complexities of globalization, cyber regulation, environmental governance, and human rights protection. Colleagues recall his classroom as a space where rigorous analysis met profound ethical reflection, a scholarly environment that empowered students to become reflective, responsible legal practitioners. Today, we are privileged to benefit from his rich expertise, his commitment to legal education, and his unwavering pursuit of scholarly distinction. Please join me in extending our warmest welcome to Professor Dr. David Ambrose. We look forward to his address and the valuable perspectives he brings to our gathering. Thank you.
Thank you for the wonderful words. Most respected and my beloved friend, Manoj Kumar Singha, Honorable Vice Chancellor of DSNLU, and Srinivasulu, again my good friend from NUJS, and Professor Kenneth Payne, from the African country, and also Professor Dr. Mirza Asman Beg, and the other speakers like Atul Alexander, and also Banerjee, Cheka Banerjee. Again, all of we meet every often in the international academic endeavors. And my good friend and also my long time association with the Mysore University Department of Law, School of Studies in Law, is more than 2 decades old, and my congratulations are to Dr. Benjamin and his team, faculty and friends, faculty members and students for selecting a topic it is called evergreen topic, the right to the right of self-defense. So I am tempted to. I just wanted to. Though I had some work. So I said I told Benjamin I will join by 2 o'clock. I wanted to listen to just get warm up after listening to an erudite scholar Manoj Kumar Singha. So still touching the subject because I retired 6 years ago and every now and then I would touch. So thanks for the organizers for giving an opportunity to brush up my memory on international touch. So thanks for the good words of introduction, but I remain to be a student of international law, ever a student of international law, because that is a fascinating subject. So a student of international law is like a ghostbuster. International law is everywhere, and still people are asked whether international law is true law or whether it is a weak law or whatever it is. So it is when nations disobey, what will happen? So that is the $1,000,000 question. So importance of international law has been felt nowadays, and I'm happy that such topics are selected for discussion on this webinar. So I will focus on the right of self-defense in the contemporary era. That's what I thought I can speak for 10 to 15 minutes on this particular thing. What is the developments, changes? What are the changes between the traditional international law and contemporary international law, as well as the right to self-defense or right of self-defense, whatever you may call it. So now my first question would be whether it is a right to self-defense or right of self-defense. This will be my first question, because like it is a preamble to the Indian Constitution or preamble of Indian Constitution. So what we have so many jurisprudential questions. preamble to Indian Constitution, preamble of Indian Constitution, like that. It's a right to self-defense or right of self-defense. We'll discuss it. We'll come to that later. So now the wonderful thing is it is an exception to 2.4. We all know. So the unilateral use of force is prohibited by Article 2.4 under Article 2.4, which has been rightly been said recognized in customary international law as well as in the customary the conventional law, treaty law. In the Nicaragua case, it has sunk to the level of the just cogence also customary international law. The prohibition of unilateral use of force is recognized as a treaty law as well as in customary law. Therefore, it has attained the just cogent status. All these things. So the first thing, anything as rightly pointed out by the organizer, Professor Benjamin and Dr. Professor Singha. So it is an exception to 2.4. So 2.4 is that is we are not studying international law of war. We are studying international law of peace. So the objective of international law, which has been reflected in Article 1, is to maintain international peace and security and promote respect for the human rights, fundamental freedoms, and human rights, friendly relations, etc., etc. Very rarely we see the word justice recognized. The purpose of international law is to render justice. Very rarely we see that particular thing. That is why the main objective of international law that has been after the Second World War is to maintain international peace and security. That is why Article 1 as well as Article 2, Article 1 talks about the purposes of United Nations and how these purposes of United Nations will be achieved through the principles of international law, principles of UN Charter. That is what 2.4, whatever it is. So now the core issue with reference to the core subject matter is with reference to 2.4 is political independence and territorial integrity. So anything happens, that is no state will no state will resort to war or unilateral use of force then against the political independence and territorial integrity. So the 2.4 talks about the thing is maintenance, apart from maintenance of international peace and security, the sovereign equality, or it recognizes the territorial integrity and political independence. So that is what against no one should, no state should state whatever it is. So the first thing is in those days only the subjects only the states were considered as subjects of international law. So that is what traditional international law. First deviation I would like to say with respect to no state shall take any action, unilateral military action against the territorial independence and territorial integrity and political independence state. So this is the first one. So now we are in the era of 21st century. We are talking about non-state actors, not because Professor Singha is an expert in international humanitarian law. So we are talking about non-state actors, individual criminal responsibility. That is why ICC has been established. That is when earlier state responsibility was there. So we thought it is inadequate. Therefore, we moved to fix individual criminal responsibility. We established an international criminal court, and that is permanent criminal court instead of ad hoc tribunals. So individual criminal state responsibility. That is why we have so many. That is why today we are talking about non-state actors, whether it is a terrorism group or individuals or head of a state, that is individuals as subjects of international law. Or I put it in that way, not only states, but there are non-state actors as the subjects of international law. So earlier, no state is prohibited to use any unilateral use against the political independence and territorial integrity or whatever it is there. So now whether Article 51 of UN Charter is an exemption to 2.4. Yes, there are certain exemptions to 2.4. One is this one, self-defense. Another one is intervention, that is humanitarian intervention, and to some extent terrorism also. All these things we say. So now moving on to the second thing, whether it is a right to self-defense or right of self-defense. If you read Article 51, it talks about right of self-defense. So right to, normally jurisprudentially speaking, it talks about entitlement. I can do something, an action, permitted action, or whatever it is. When you when you say it is a right of whatever it is normally we mean inherent entitlement. That is why Article 52 also talks about the inherent right of self-defense. So the right of self-defense, whether we right to normally, because we can talk in both senses. That is why that is the point I would like to make. So there is a duty not to use force. From this duty, you get a right. So the right to self-defense. When somebody uses unilateral force, military forces against against a state's political independence and territorial integrity, then via Article 2.4, you get a right to self-defense. So when somebody attacks, so there is a negative duty imposed on the states not to use unilateral force. But when the duty is breached, that is like something like Article 21, duty to not to interfere, the duty to protect the life or whatever it is. No person shall be deprived of his life. So from this duty, negative duty, you get a positive right to self-defense, jurisprudentially speaking. So that is why we have a confusion between right to self-defense and right of self-defense. So somebody attacks, somebody attacks you. So again, an attack is, a military attack is there. For example, number one, against your political independence and territorial integrity, then you have a right to defend yourself. So that is why if it is an exemption to Article 2.4, that is why it is called right to self-defense. But actually, if you read the wordings of Article 51, it is called right of self-defense, inherent right of self-defense. So it is inherent. So that is what something we say. When we say inherent right, so the courts have inherent right to, especially in federal countries, the courts have inherent right to judicial review. And you can't oust the jurisdiction. That is what we say. So it is inherent. If a state is having a statehood because of the recognition of everything, you have a defined territory, stable population, able government, and you are willing, and we have a ability and willing to discharge international obligation. You have a personality, international personality. You are a member of the international community. Then you have a right of self-defense when somebody attacks you. So this is what I call right to self-defense and right of self-defense. It is inherent. Even Article 51 talks about right self-defense. Why I am talking about this inherent right of means, from this point only we have to take it to the next level, whether Article 51 is the codifying of then existing customary international law, or it is simply codification, whatever it is. If it is a customary international law, then inherent self-defense will automatically mean what we call anticipatory self-defense. I'll come to that later. Now, the first thing is, the first one is right to and right of self-defense, number one. The second thing is there not only a state, earlier it was a state, now today in the 21st century, we are talking about non-state actors, especially terrorism and individual groups or militant groups. If they do something, they use military power against the political independence and territorial integrity, whether you call it as a right to self-defense or right of self-defense, the state can use force, minimum force or whatever it is. I'll come to that later. This is the first point I would like to. The second thing is with reference to armed attack. So this is what normally we say. So self-defense must commence only when, that is a Lakshman Rekha, we call it. So when there is an armed attack, unprovoked armed attack against your political independence and territorial integrity, you have a right to self-defense or right of self-defense. So that is what today in the 21st century. So this is also under contemporary international law. There is a deviation, there is a development. There need not be a armed attack at all. That is why we call it as an anticipatory self-defense. So something, if you anticipate some armed attack will be there, so then you can anticipate and you can invoke Article 51 as a right of right of self-defense. This is mainly during the height of Cold War, and also with reference to the arms race, that is nuclear arms race. So that time they said, when there is a nuclear attack is there, so that you will not have time to retaliate. So that question, only after armed attack I can react, that is self-defense. So that question becomes irrelevant. Logically, there is no reason to uphold this. So when there is a nuclear attack, you will not have time to react or whatever it is. Therefore, we go for anticipatory self-defense. This is what normally they said with the Cuban quarantine case and other things. That is what a lot of case studies are there. this point is that is what we call it as a not only armed attack, anticipation armed attack, whatever it is, we will appreciate that. Now coming to the classification of self-defense, the first classification under Article 51 is collective and individual. Collective self-defense, because the purpose rightly pointed out by the Singha sir, the purpose of United Nations is maintenance of peace and security, friendly relations, therefore collective security. So if there is a threat to peace anywhere, that is a poverty anywhere, threat to peace everywhere, we say. If there is a injustice anywhere, threat to justice everywhere, like that. If there is some kind of armed conflict anywhere in the thing, it affects the international peace and security. Therefore, the collective self-defense was recognized. Security Council will go for a collective defense, all these things. Once some countries also will call for, I am unable to protect my territorial integrity, political independence, therefore they can ask for a collective thing. And the NATO principle, that is what one of the issues with respect, now we are facing with the what we call the Ukraine and Russia conflict. The NATO, they wanted to become, the Ukraine wanted to become a member. It was invited to become a member of NATO. The policy of the NATO is, if one country is attacked, if the one country of NATO is attacked, and they will think that the attack is done against all the members of the NATO. So that is what we call it as a collective self-defense. Self-defense. Now then we have individual self-defense, that is collective or individual. That's what Article 51 says, collective or individual self-defense. When individual self-defense, that is what we have been talking about, that is, it is a right of individual self-defense when there is an armed attack takes place against the territorial integrity and political independence, or whatever it is. So now that is what, so this was in the traditional understanding when the charter was drafted, this was. So during after 1970s, 80s, so if you trace the development, then we have anticipatory self-defense. So that is why the million-dollar question was whether it is a customary international law, or that is inherent right of self-defense, or it is a codification of that is what progressive development of international law, or codification of then is existing international law. So many writers thought that it is a codification of then existing international law because of the use of the word. That is what is inherent power, inherent right of self-defense. So anticipatory self-defense is incorporated with this. So I'm not going to move on this. Many writings are there. You can read it. Many textbooks are there. You can read it. So I will move on to the next one. Preemptive. That is what in the 20th century. Now we are in the 21st century. Preemptive 21st century also preemptive self-defense. So it is like elastic self-defense, anticipatory self-defense, and we have preemptive self-defense. So now the reason for this elasticity is obviously three. Already I mentioned that it is one thing is not only states are attacking the there is an attack on not only by the states but also non-state actors with reference to the political independence and territorial integrity of a particular state, member state of United Nations or international member of international community. So that is what normally we say. So now what is this the anticipatory self-defense, and we are moved to preemptive self-defense, obviously for two reasons. One is what you can't do directly, you are trying to do indirectly. It is a colorable exercise of use of power. Number one, the reason for recognition of preemptive self-defense is colorable exercise of military powers. So I cannot use directly power against military power against territorial integrity and political independence of a particular country. Therefore, I encourage cross-border terrorism. So state-sponsored terrorism, I'm not talking about state terrorism, state-sponsored terrorism and cross-border terrorism necessitated for a discussion or a recognition of this preemptive self-defense. So three things important. One is, so the non-state actor attacks, attack is done against the territorial independence and territorial integrity and political independence of a particular country, not by a state, by a non-state actor. Here it could be a terrorist group or whatever it is, all these things. And And the second thing is, the important thing is, what you cannot do directly, you are doing indirectly. A colorable exercise of military powers, or state-sponsored terrorism, or cross-border terrorism, resulting in the creating chaos within a particular country or whatever it is. So this is what normally we say. So Bush rightly pointed out by others, they justified, American justified it. They saw it's a just war against terrorism. So I don't know, war itself is prohibited. I don't know what is just war. So we have a rogue states now. Earlier we have a classified civilized and uncivilized, not civilized states and other states. Now we have a states and rogue states. So some rogue states, so they encourage terrorism, or in the name of I don't want to go into political issues, because they encourage what they cannot do directly, they are doing indirectly. Therefore, it is called preemptive self-defense. So now the preemptive self-defense, earlier there were certain, it is a right of self-defense, whatever it is. Any right must definitely have some limitations. One thing was, it is with reference to Carolina case. That is what we all know. The UK drowned the SS Carolina belonging to the American things, because they suspected some anti something against the state was done, and one American was died, etc. So two things emerged. One is imminent danger, and rightly pointed out by Professor Singha, proportionality test. So this is what. So now with reference to the imminent danger, so you can that is what in Falkland Island issue also they said, immediately imminent danger, there is a threat to your political independence and territorial integrity, you can resort to use of force. That is article exception to 2451, yes, and immediately you have to report to the Security Council. And once you are resorted, you have to stop it, and whatever it is, and all these things we all know. Yeah, the Security Council must be informed, and when the Security Council takes charge of it, then you have to stop it. All these things we know. This is what. Now, adding to this proportionality test is there. So immediately when Israel attacked or retaliated the Hamas, everybody, including India, for the first within 24 hours, we all supported Israel. So we all supported. International support was huge for Israel. Nobody commented against it. So 3 days, 4 days, after that, everybody started condemning Israel, including India. So why this is what? The first initial thing was considered to be right of self-defense. So when it exceeded, and it amounted to the, sometimes, I'm not calling it, sometimes according to the ICJ also, genocide. So that is what we call proportionality test. So what you are going to is, to protect your territorial integrity and political independence, you can use, you can invoke, use military power, but not to indulge in genocide or whatever it is. That is what we call as the proportionality test. And when on one essential condition under the proportionality test, both under the responsibility of state, is your act must be able to be revoked, or whatever it is, whatever the damage you are going to do must be, I think the clock must be able to be set back. So that is why the damage done to the particular country must be reversible. So in case if it is not reversible, then their proportionality test will squarely will fail. So this preemptive, the preemptive self-defense, right of preemptive self-defense is very much recognized. So India also used this surgical strike. Earlier we used it as a humanitarian intervention in what you call in the Bangladesh issues and all these things. Now today we have used this surgical strike preemptive measures. So that is what normally we say, because it is a terrorist group, non-state actors. There is an attack on there is armed attack or whatever it is. There is no direct armed attack, but not by a state, non-state actors. Then we are resorting to the right to anticipatory. Right to preemptive measures, all these things. So these collective measures, that is what we saw in Iran's case, that is Saddam Hussein's case. It was a collective self-defense, they called it, and then NATO also calls it the collective self-defense, and we have individual self-defense because of the non-state actors and Bush doctrine, rogue states, surgical strike, and also specifically addressing a particular issues. So this is what I'm just because I thought I can share some of my thoughts on the right of self-defense or right to self-defense in the contemporary era. So thank you for the organizers. So I thought that this because we are not supposed to talk a lot because we are guest of honors. We have to kickstart the thing. We have to then rightly the next things they'll go. We have to touch the like keynote speakers. We have to just generate heat so that heat will be carried out. We have to set the wheels on motion. I think Professor Singha did a right work and I followed his suit. Thank you for your wonderful opportunity. I'm also eager to listen to the other participants at a micro level, what they say as a case study method or whatever it is. So I once again thank Professor Benjamin and his team for having given me opportunity to share my thoughts for 10 to 15 minutes on right of self-defense in the contemporary international law. Thank you so much. God bless you all.
Thank you, Professor Ambrose, for your thought-provoking and comprehensive address to the international humanitarian law with various dimensions. Now, I would like to request our co-host, Ms. Sarah Benjamin, to introduce Professor Mirza Asmer Beg to share his insight with us. Ms. Sarah.
It is my pleasure to introduce our speaker today, Professor Dr. Mirza Asmer Beg, Professor in Law, the Department of Political Science at Aligarh Muslim University, India, and a renowned specialist in strategic studies, international relations, and electoral studies. Professor Beg's outstanding academic credentials include a doctorate recognized with the Best Dissertation Prize by the American Studies Research Center, Hyderabad, in 1996, a seasoned scholar. He has published widely in journals such as The Round Table, Economic and Political Weekly, Seminar, and Studies in Indian Politics, contributing to nuanced discussions on electoral dynamics and strategic policy making. He has held a Fulbright visiting scholar post at Southern Illinois University in 1999 and is a fellow of the Salzburg Global Seminars in Austria. Professor Beg also serves on editorial boards of international journals and contributes as a referee, shaping scholarly discourse in political science. Locally, he coordinates academic surveys in the UP Western region for the Center for the Study of Developing Societies. His recent work includes exploring the political representation of minorities, particularly Muslims in India, such as the delimitation and political underrepresentation of Muslims, and analysis on voting preference in the 2014 parliamentary elections in Uttar Pradesh, published in the Round Table. Today, we are honored to hear from a scholar deeply versed in India's political fabric and global strategic thought. Please join me in extending a warm welcome to Professor Dr. Mirza Asmer Beg. Thank you.
The floor is yours. You may proceed, please. You are unmute, sir. Sir, we are not able to hear you. Please mute and unmute. Okay, fine. Let us try.
Okay,
Yes.
fine.
Yes.
Thank you. Can you hear me?
Yes, sir. You're audible.
Oh, fine. Thank you, Sarah, for a very generous introduction. Thank you, Professor Benjamin, for inviting me and having me at this intellectual conclave. And thank you, Qudrat Hashmi, for facilitating my presence in your seminar. And I was listening to some of the initial remarks by Professor Sinha and others in the beginning. And unfortunately, I had some other engagements, so I had logged off in between. But anyway, I could get a sense of what was being discussed by legal luminaries here. And I'm a student of international politics, so I'll try to bring in a different perspective to our discussion here today. And I would try to understand the politics, which operates in this context. If you look at the world post 1945, so this world which emerged after the end of the Second World War, we all understand that this world, or the structures or institutions in this world, were all facilitated and shaped by the Western world, led by the United States of America. And they had very clearly understood that in the times to come, it would not only be force or brute power which would determine the contestation in international politics in the times to come. And they would need to devise some new instruments to ensure that their control in the world or in the international system continues as it had been before that, when the Western civilization continued to dominate over the whole world for several centuries. And that leadership now was in the hands of the United States, but the other players remained the same. So what they decided was that we need some new instruments by way of which we can ensure that other countries of the world behave in the international political arena the way we want. And one of the very important instruments which they centered upon was the instrument of law. And I wanted to highlight this because you all are people of law, and therefore we need to talk about how law was instrumentalized by the Western world, led by America, to ensure that it is a very useful instrument for them to control other countries. So what they did was that they decided to create different institutions. And the most prominent institution which they helped create was the United Nations Organization. So although the professed aim of the United Nations Organization is, of course, to maintain international peace and security, but what do they mean by international peace and security? International peace and security on their terms. So the United Nations Organization, the International Monetary Fund, the World Bank, the GATT, General Agreement on Trade and Tariffs, and so many institutions were created around the same time. And the purpose of all these institutions was to ensure that these institutions worked in a manner to basically fulfill the objectives of America-led world order. So if, for example, if America were to tell other countries to do things what America wanted, we would be very hesitant. We would not take orders from America. But what they decided was that we will create institutions. And these institutions will tell countries to do what we actually want. So that will facilitate changing the behavior of countries. So rather than America or the Western world telling us directly to do or not to do something, it was these institutions which were telling us, which have been telling us all these years. And we have been very nicely following what these institutions say. And most of the times, these institutions have been acting exactly what or how they want. And you can very nicely see the example of the UN, that till the time the UN, or most of the times the UN had been doing things which the Western world wanted. And whenever the UN, for different reasons, in the later years, decided to do something else or look the other way, the Americans and others were at the throat of the UN. They said that UN is useless, we don't want this. And it is doing something wrong. And it is playing politics, and all kinds of accusations were hurled on the UN and institutions and specialized agencies of the UN whenever they saw that these institutions were doing certain things which were not consistent with their own selfish interests. So the point is that basically these institutions were created to serve their interest. So till the time these institutions would serve their interest or continue to serve their interest, it is fine. But the moment any of these institutions would be doing something independently, the US and its allies would not like it. And as you saw the example which was given by Manoj Sinha in the afternoon early, that when the first West Asian War happened in 1990, when America invaded along with 36, 37 odd countries under the sanction of the UN, Americans were very happy that the UN had given sanction to invade. But when in 2002-3, when the UN was reluctant, America started delegitimizing the UN itself. The same UN, yesterday it allowed you to enter a country and do whatever you wanted. So you were very happy. But the same institution, when it is saying something, on certain logic, of course, that where is the evidence? Where is the proof of the weapons of mass destruction in Iraq? Why do you want to enter that country? So they say that, no, we don't want any sanction of the UN and we will intervene. Rather, their lawyers started interpreting the condemnation of the UN as a permission to invade. Similarly, in the case of the Balkan Wars, the UN did not give an express permission to America to invade Bosnia-Herzegovina in the Serbian campaign when America bombed that part of the world. But they said that, okay, fine, when the UN is condemning, that is actually the intent of the UN. So my intent is being interpreted by you. So the UN intent is being interpreted by America and Britain, and they are saying that, okay, fine, it is what the UN actually wants, and we will go and intervene. So similarly, in other places also, they would stretch the argument too far just to ensure that they are able to do what they want. So the point basically is that in this post-Second World War world order, all what has happened through these institutions and through these, structures which were created in the world, we are, developing countries like us, we are most of the times under the illusion that these institutions have been created for us because we are large in numbers, but actually the levers of power are in the hands of the US and its allies. And that's what they've shown at different points of time. And whenever it is their interest, you see that the UN is sitting like an important body, like in the issue of the Gaza war, ongoing war in Gaza, the American and Israeli attack on Iran, and so many other instances, when these institutions would take a back seat and America and its allies would go and do whatever they want in whichever part of the world. So basically, that is the reality of the structuring of these rights. Another important thing which I would like to flag is that the moment you say this word right, again, you are people of law. In the state system, we have rights, fundamental rights, but the state is the guarantor of rights. So if I'm a weak individual and I'm a mere individual maybe, and my rights are being trampled, I can approach the courts. I can go to the High Court, I can go to the Supreme Court with writs, which I have got. And I can see to it, or those institutions will see to it that my fundamental rights are protected. But at the international level, the moment you say the word right, who has the rights? International system is like a jungle where might is right is the principle. So like in a jungle, all rights are with the lion or with the powerful animals. There is no right with the rabbit or the deer or the other weaker animals, physically weaker animals who are at the mercy of the carnivores. And the carnivores would decide what they want, when they want to eat, when they have their belly full, and whenever they want to leave you or whatever they want to do, it's how they operate. So in the jungle, the word right is with the animals who have the power to claim their right. Similarly, in the international arena also, who has the rights? What rights in effect at the operational level do weak countries have? What rights does Bhutan have of self-defense? What rights does Lesotho have of self-defense? Or a host of so many countries. You can name any of those countries. What rights they have? Whatever happens to them, whosoever tramples their sovereignty, whosoever enters their country. And recently you have seen, the American president, the honorable American president claiming rights even on countries far off like Denmark. Even claiming rights on their own friends, traditional friends like Canada, that Canada should be the 51st state of America. America can say that, but Canada cannot say that. So the lion can say anything, but the lamb cannot say anything. The rabbit cannot say anything. They don't have any rights. So this whole issue of rights, by its very structuring, by its very configuration, is in favor of those powerful countries. So apparently it looks that when you talk of right of self-defense, it appears that it is for everyone, but actually it is not for everyone. It is only for the powerful. And we have seen that it is the only powerful who exercise this right. Never has in the world since 1945 any weak country been able to exercise this right. So are we so naive as to assume that weak countries do not have any problems? In fact, weak would have more problems. Weak would have more transgressions. Weak would have more, dominance, rather attempts at dominance by stronger countries. But they can't do anything, they die unsung. But the powerful countries would always claim the rights. And then when we are technically talking of this right of self-defense, we talk about the two concepts of necessity and proportionality. Here again, it's if you deconstruct these two terms, it again is very, very biased in favor of the powerful. When the lion is hungry, he decides it is necessary for me to kill someone. So the principle of necessity is decided upon and operationalized by the lion, not by the weaker animals in the jungle. Similarly, in the international system, who decides the necessity? America decides the necessity. That although all terrorists who are involved in the 9/11 attacks happen to come from some other country, but America decides to invade Afghanistan and Iraq. They are not going to, at least, there would have been a semblance of logic if you said that all these people are coming from this country and we are going to, although again, it is contestable that if some people from my country are doing something, why should all of us Indians be punished for that? But anyway, there can be some semblance of a logic. But once you say that all these people, and you are yourself saying that they are all coming from country X, and then you go and attack country Y and Z, and we all understand what is the logic of your attack. So the necessity is decided by you. You decide when to attack, whom to attack, how to attack. The weaker countries would never decide. And it is the right of self-defense of the powerful. Again, very ironic. Actually, this right should be of the weak, The powerful are never threatened, They have the power. They can get whatever they want. They can dominate over others, They have been dominating over others. They have been terrorizing others. They have been doing all kinds of wrong things in the world. But they have the right, and then they decide the necessity. And interestingly enough, they also decide the proportionality. How much punishment I can inflict on you. How much bombs I can go and deliver on your country. So when the World War was ending, they decided that although the war had already ended, but America decided to go and drop nuclear bombs on Nagasaki and Hiroshima. And just to protect America in future. You see, this is on one side of the world. Japan and America is on the other side. Japan is already beaten in the war. They are already, counting their losses. And there is no possibility of Japan now attacking America in any foreseeable future. But still you go and drop that bomb there just to demonstrate to the world that you are the new superpower in the world and you are coming in and nobody should dare touch you. And then you decide in all cases, how much is enough, you decide. You go and keep on bombing Afghanistan for 10 years and then you retreat saying that, okay, fine, this is what we wanted to do there. You go and kill 6 million people in Iran. And that is maybe enough for you to satiate your desire to kill people. And now you are ensuring that your illegitimate child, that is Israel, will go and keep on killing people in Gaza and do whatever they want. And you are there behind their back saying that, okay, fine, this is the right thing which you are doing. So any definition of proportionality, falls out, or rather is not able to stand in front of this interpretation of that term, which is so very blatant, so inhuman, so immoral, and whatever words you can add to it. So that is how the world is structured. So the point which I'm basically trying to make is three. Firstly, I was trying to say that why this principle came about. This principle was structured by the powerful countries of the world, led by America, to ensure that they would use this principle when need be to further dominate and enslave the other countries of the world and to exploit the third world countries of the world as and when need be. And they also knew that the moment, at any point of time, if this principle will come in their way, they will again go to the extent of even delegitimizing it and saying that what the international organization is saying is wrong, because the international organization itself is delegitimate or non-legitimate, at that point of time. And we have seen at different points of time that America has threatened these international organizations. They have threatened the World Health Organization, they have threatened the UN itself, they have threatened the International Criminal Court, and all such structures which were structured by them only. It is not that these institutions and structures were created by third world countries like us. We never created them. They created all these things, but they want 100%, compliance to what they want, what their interest is by these institutions and structures. And the moment or at any point of time, whenever they see that even there is an iota of, deviance from that interest, which they want to serve, they go on and delegitimize these institutions and structures, anywhere in the world. So therefore, we have to take these principles with a pinch of salt. We have to look behind them, try to scratch the surface and try to understand that even if there are principles, they are very dangerous. So whenever there is a principle made, the first thing which we need to ask is, very famously, Robert Cox, a very famous political scientist, gave a very nice, sentence he wrote, which is very much pregnant with ideas, that no idea in the world is neutral. And very rightly so. So whenever anything is created in the world in the name of everyone, it is never in the name of everyone. It is always in the name of the creator of that principle. And here we are very clear. We all understand, it's not a secret who created these principles, who institutionalized these principles, and who is at the helm of operationalizing these principles. It is the West and the Western world led by America. So whenever these principles will work in their interest, it is no surprise. Surprise will come whenever at any point of time, some of these principles go on and they work in interest of countries like us, relatively weaker countries, which will never happen. So therefore, whenever any such principle comes out in the world with a very nice and fancy name, very attractive name, we, that is the third world countries, need to always take it with a pinch of salt. Like, for example, the principle of humanitarian intervention. It's like very pleasant murder. So they want to kill you, and then they want to use a very nice term, humanitarian, for intervention. Means they want to enter in your country blatantly, and then they gave it the name humanitarian. Then they go even further, and then they say responsibility to protect. Who gave you the responsibility to protect me? Who gave the lion the responsibility to protect the lamb? And if the lion has the responsibility to protect the lamb should always be counting its days, and because its death is very near. So that is what is happening in the world. So I just wanted to throw light on this political dimension of, of structuring these ideas, how these ideas are structured, from where they come, who makes these ideas, in whose interest these ideas work, and how countries from the third world, need to be very cautious once we approach these principles, and we have to rather tread very carefully when we approach these principles and try to understand how they benefit us and how they are rather useful and beneficial for the world at large. So basically, these were just a few stray thoughts which came to my mind, and I thought I should share it with you. And of course, lend a different color to this discussion, because you are all people well versed in law and international law. And all day through, you have been talking on the legal dimension, but I thought that political dimension is always important, because nothing in the world can escape politics, and it's always there, whether nationally or internationally. Thank you.
Thank you, sir. Thank you so much for your stimulating and thorough analysis on the intersection between law and political science in the context of self-defense. Added a critical dimension to our discussion for today. Thank you so much. Now, I would like to request Ms. Sarah Benjamin to introduce our next speaker, Professor Banerjee. Sarah, over to you.
It is my privilege to introduce our distinguished speaker, Professor Dr. Banerjee Chakka, Professor of Law and Dean of the Vellore Institute of Technology, Andhra Pradesh, School of Law, VIT Andhra Pradesh University. Dr. Banerjee's academic journey is truly remarkable. He holds a BA LLB honors from Andhra University, an LLM from the School of Oriental and African Studies, University of London, and an MPhil and PhD in International Law from Jawaharlal Nehru University, New Delhi. He has also earned a postgraduate certificate in teaching and learning in higher education and a postgraduate diploma in French language and culture from the National University of Ireland, Galway. In recognition of his academic excellence, he was awarded the prestigious British Turing Scholarship at the School of Oriental and African Studies in 2015 and 16. His professional experience is equally diverse. Dr. Banerjee has served in leadership roles across leading institutions, including as Dean Interim at Alliance School of Law, Bangalore, Associate Professor at Symbiosis Law School, Hyderabad, and Registrar and Associate Professor at NLU, Assam. He has also taught internationally as a lecturer at the National University of Ireland, Galway, and served as regional legal advisor to the International Committee of the Red Cross, leading its South Asia delegation in New Delhi. In addition, he has been closely associated with the Indian Society of International Law and has contributed extensively to research and policy in international law, humanitarian law, and legal education. His unique blend of academic, administrative, and international experience makes him a highly respected voice in both national and global legal circuits. We are honored to have him today with us. Please join me in extending a very warm welcome to Professor Dr. Banerjee Chakka. Thank you.
Thank you very much, Sarah. I hope all of you are able to hear me. And thank you very much for the warm introduction. And also, I'm grateful to Professor Dr. M.S. Benjamin, Dean Faculty of Law, Chairman and Professor of Law, Department of Studies in Law at Mysore University, and distinguished keynote speakers, distinguished chief guest Dr. Manoj Kumar Sinha, and our guest of honor Dr. David Ambrose, and other co-speakers like Professor Atul Alexander from NUJS and Professor Mirza Asmar Beg from Department of Political Science, Aligarh Muslim University, and Dr. Kenneth from Mount Kenya University, Kenya. Indeed, it's a great privilege and it's a pleasure speaking to you, audience of international law in this afternoon. And I was keenly following to listen the opinions and the aspirations shared by the people. It's very interesting. And prior to me, I could see that Professor Sir is speaking about the interface between the international relations, the current political scenarios, and he has given the beautiful history from the 1945. The so-called New World Order has been created by the so-called civilized countries, that is a global north. And now today we are looking at this reinventing the concept of the self-defense, and we are debating on that. What is the necessity of it? And what is the utility of this particular principle? And why the charter, while beautifully carving out all the glorified principles of international law, and we call it as the basic fundamental principles of international law, or basic principles of the modern international law. In the language of global north, we say that settlement of disputes in peaceful manner, prohibition of the use of force, and so on and so forth. The 8 fundamental principles we read in the context of the Charter of the United Nations, and that is the foundations and the founding purposes of international law. And we were taught and told by our scholars and practitioners and professors of international law that these are the foundations of international law, and this is the norm which created. But when we look at it, the background and the history, it suggests that it is disadvantagedly carved out for the benefit of global north. That's what our scholar, professor of international relations, he spoke very eloquently that. Thank you, sir, for that, giving a very good background of that. And now if you look at that today, I'm going to go little deviation. I don't want to stay there, whether self-defense and what is the status and what is the political nuances. And if all of you read very carefully Article 51, which clearly says that nothing in this present charter shall impair the inherent rights of the self-defense. That itself shows that it is whatever the objectives which we are talking and preaching. Last 80 years, we have been talking about that. These are the golden principles of international law, have completely put under the cold storage and they kept in the freezer. And it's right. They will defreeze it whenever they want. Okay? They defreeze it. And when they defreeze it, when it is against to the principles of them, and they try to reinvent the wheel in the name of new things. Like sometimes we call it as a peacekeeping operations. And we know that during the Cold War, when United Nations Charter, if I say so, it's a defunct virtually. And if I say so, the United Nations Security Council was completely defunct, not working. Suddenly, the proactive General Assembly and proactive Secretary General of the United Nations came out with, let's go do some peacekeeping. And whose peace you are going to keep? First of all, did you let the people live in the peace? No, I don't think. In the name of self-determination, when people are fighting, and you said, oh, that's not our headache, and simply you escaped, then what happens to your white man's burden during that time? You never came up. That so-called responsibility to protect, like our professor just now used. What happened to your responsibility? And when millions of the people have been killed in during the Cold War, in the territories of Africa, particularly in places ethnic cleansing was happened, in Rwanda, what happened to your responsibility to protect and your white man burden? You never spoke about that. You never thought about it. That is a humanitarian intervention, what happened? And you never remember to defreeze the so-called principles of international law and have a mechanism called self-defense in order to protect and promote the basic rights of the people, which are enshrined under the United Nations Charter and Universal Declaration of Human Rights. Now, when suddenly some attack happens, you realize that globe is under threat. You unleash the humanitarian catastrophe in the name of global war on terror and massacred the people starting from Afghanistan to Somalia, Syria, Libya, and still that massacre and butchering is happening in the Gaza Strip. It's a clear evidence of the failures of the normative structures of international law. So in the midst of this, I'm going to talk, the one aspect is that now this particular defense, the self-defense, what is its validity in the days of the new and emerging technologies? We never realized that the utility of the self-defense. The so-called civilized sovereign states will have that particular self-defense because the reading of an Article 51 clearly says that nothing in this present charter shall impair the inherent right of the self-defense of a sovereign country. So that means in a sovereign country, you have a self-defense. And now you are trying to unleash that self-defense in the today name of principles of international law. Now today, when we talk about that, the new and emerging technology, my argument, my point is, which I would like to say that, in the age of new and emerging technologies, how are we going to invoke the so-called principles of self-defense And are we going to justify it? How we are going to justify it? And here, in the context of the Article 51, we clearly said that there should be an actual armed attack must have been taken place by the victim state. And what do you mean by the article armed attack? Where Article 51 never defines what would amount to in Article 51 armed attack. They never define. And even we can go to that, the very good jurisprudence given by the Global South judge in the Nicaragua. And he said that in the Nicaragua case, mere frontier incidents cannot contribute to the activities which are undermining the territorial integrity and political independence of a state. They cannot be considered as an armed attack. And if people want to read it, and they can read it from the Nicaragua case, it's a page number 125 of 1986 judgment of the International Court of Justice. Now, today the language is changing. And now, recently, I was writing an article about the cyber warfare and international law. One particular chapter is that self-defense in the context of the cyber warfare. And in the self-defense, we clearly look at that, how this particular self-defense may justify the state's use of force. And when we talk about that, if there is an actual attack happens, if the victim state can have a unilateral or collective security measures, they can go and take action against the aggressor state. That is justified under international law. But in the case of today, if any cyber attacks happens, if that is not reaching to the threshold of the armed attack, can you invoke the principles of self-defense? But let me ask you the question, saying that who decides what is the threshold? Should we respect the judgment given by the Global South judge in the Nicaragua case? Does it have any persuasive value for the most powerful states, those who are left, right, center, undermining the relevance of the normative practices of international law? And what happens if a single attack on a military platform or installation, does that meet the threshold? Or maybe you invoke the same principles of what you have invoked in 2011, the 9/11/2001, the so-called preemptive self-defense. Can we use that metaphor of the preemptive self-defense? Or can you qualify? So these are some of the new questions which are evolving, which are not answered by the normative framework of international law. Sometimes this is a very interesting, sometimes it's a very problematic, because we are dealing with the unregulated expansion of the cyber activities, where these activities, the activities are intensifying of the cyber threats, which have been unveiled for the intrinsic deficit in the existing international legal order. If you look at that, the normative traditionally adopted mechanism of Article 2, Clause 4 and Article 51, it's only designed for our understanding the conventional areas of warfare, but they are inadequately formulated to deal with the sovereignty, our accountability, our protection of the critical infrastructure issues which we are experiencing today. And why I am raising these particular issues, if you look at that since 2005 onwards, there is a cyber attack on Estonia in 2007, and a cyber attack on Ukraine in 2015, and NotPetya, that ransomware, a malware which has been used, and the Viasat attack in 2022, and Stuxnet, and obviously the other one. And these kind of case studies which provoke us in the context of whether the current premises of international law is going to suffice to address the problems of which, where the global north is trying to take advantage of it and trying to punish the global south. Because as I take a cue from our professor of international relations from Ali Gert, sir said that the international relations always, our international institutions are always disadvantagedly created for the purpose of sufficing the needs of the global north. In that there is no doubt, we have to accept it, being a students of international law from the global south. But since we have to earn bread and butter and we have to survive, we have to preach international law. That is, what we have in Article 2.4 is a jus cogens principles of international law. Okay, so, but when you have critically this kind of webinar, we need to question, we need to talk, we need to look at it. And I will refer that one particular article when I was reading, it is a very disturbing thing, that is, they're trying to qualify cyber attack and they are arguing for taking in a preemptive action. There is an article written by the Michael Schmidt. And I don't know how many of you are aware of his writings. He's one of the good writer from the Durham University. Later, he was in head of the department in international law at Naval War College, and he is trying to suggest there are 5 to 6 methods where if the cyber attack happens, particularly, we should be measured in the 6 factors. And he says that in a severity, the type of the scale and the harm which is happening. So that means he did not write that whether it is a preemptive or actually the attack was happened. After attack, you are going to look at that severity, the scale of the harm which already happened on the accused, on the victim state. We don't know, that's not clear. But immediacy, and how immediate you are going to quickly, how quickly the harm materializes after that particular attack. And the third point which is giving us that is directness, the length of the causal chain between the attack and the harm. But as I already mentioned, there is no definition for the armed attack, but you are talking, and ICJ also said that the border frontier activities cannot be measured as an act of act which is undermining the territorial integrity and political independence of a state, where you can invoke Article 51. Now, the fourth point which they are saying, that invasiveness, the degree to which the attack penetrates the victim state's territory. Now, how do you interpret this one? How far it is intervened? How far you are going to measure? No. A particular non-state actors, if they come and they attack and they go, can we attribute that to that particular state in accordance with the international law articles on state responsibility, Article 19, which says something different? And measurability, that is the fifth point. Professor Michael Schmidt argues that the degree to which the harm can be quantified. How do you quantify? Now, if you are starting quantifying the attacks which happened in the context of Afghanistan to Somalia, Somalia to Syria, Syria to Iraq, and followed by today in Gaza and Ukraine, would it be possible to quantify and start taking an invocation of Article 51? If that's the case, why Security Council is keeping quiet? These are all some questions. Now, the last point which he offers is that presumptive legitimacy. What is that presumptive legitimacy? The weight given to the fact that in the field of cyber activities as a whole, cyber attack may constitute an armed attack. Is that what they are talking? So, but when you are reading that particular 6 points together, we will also have to look at that the Tallinn manual, which was adopted in 2013 by the international community, is very interesting. rule number 13 of the Tallinn manual, which says that self-defense against attack, armed attack, it's only talking about the state that is the target of a cyber operation that rises to the level of an armed attack. See, you have to read that one. A cyber operation that has to reach to the level of armed attack. Then you may exercise its inherent right of self-defense. Whether a cyber operation constitutes an armed attack, it is always depends upon the scale and effects. Let's look at that Stuxnet incident which was happened, or VSAT incident which was happened, or maybe the incident which happened aftermath of VNet, or maybe scamming of German banks and Austrian banks in 2018. There is no actual armed attack, but the financial activities of the entire, some of the European Union have completely stalled. Can we consider that as an actual armed attack? It is a freezing, and it is leading to the economic freezing of the assets of the people, so that we can have a invocation of Article 51 in the self-defense. So these are some of the questions which we comes into the picture, but there is no clarity. So that is why what I would like to say, that it is a very, very difficult proposition. So that is why I would request our scholars and students of international law, let's look at that the Nicaragua case in the light of these developments which are happening, the scale and effects. And in the Nicaragua, they also mentioned that the scale and effect criteria. And in fact, it is a qualitative and quantitative element is there in order to differentiate an armed attack. As I mentioned that, if it is a qualitative, does a mere frontier incident, or maybe hostiles are shelling between the borders, does it fall under the definition of armed attack? If in the case of a cyber attack that does not result in serious casualties, then can we invoke? So some of the issues which are very pertinent, like operating cyberspace, since we are in a borderless world, and there is increase in number of various actors carrying out the cyber attacks, that's a problematic. And this is the normative problems which we are talking about. The last problem which I would like to talk about, that what if the non-state actors, I'm not talking about the non-state actors of either armed non-state actors like rebel forces, etc. I'm technically using non-state actors such as a corporation, the big corporates like Meta or maybe other platforms. What happens if some of them are having that program where from their intermediary positions, if somebody installs the program and sends the ransomware or malware to the other thing, can we make this individual as well as the corporate entity, a non-state actor, responsible and invoke Article 51 for the purpose of the self-defense in the cyber warfare? First of all, does it amount to a cyber warfare? Where a non-state actor, being an intermediary, if other non-state actor using that particular platform and sending a ransomware and attacking and trying to stall the entire human life over there, does it qualify? And if it is, what are the destructive consequences of this one? And how do we measure what factors led to it, and how the states can take measures of the so-called inherent rights which have been given under the Article 51 of the UN Charter. So these are all some of the unanswered and contested questions. So with this, I would like to just conclude that the issue of legality of the cyber operation, so that targets some groups launching attacks from other countries, is a contentious one. So sometimes the United Nations United States justifies the actions by claiming that the territorial state whether unwilling or unable to stop the attacks, maybe they can take a rational and can invoke Article 51. So that kind of orientations are emerging today in today's world of where the new emerging technologies are coming, the new propositions are coming and taking action against that particular state. This is very worrisome and this is a very dangerous proposition, like what I read out and what I said right now. If the state, United States is saying that we can justify invoking Article 51, where if that particular state is unwilling or unable to stop the attacks which are happening from the territory through the cyber means, it very well justifies invocation of Article 2051. So this is a kind of proposition what we have in the context of the cyber warfare, where how that self-defense mechanism is going to work it out. Okay, with this a few remarks, I thank you for the organizers giving me this wonderful opportunity to share some of my thoughts, and thank you very much. And if any one of you have some questions, maybe we can. But my apologies, 5 o'clock I have a class and I need to exit. If any questions, I don't know whether I can take now. I'm sorry for that. But I've been waiting. I rescheduled my class. I thought, things will be over. And I will be here for another maybe 10 minutes. Then if any questions for me, I'm happy to take. If not, then I will take your name. Thank you so much. Thank you, Professor Benjamin and other organizers for this.
Thank you, sir. Thank you so much for your insightful speech. Sir, you may exit because you have a class. We are also left with last speaker. There will be no questions and answer session. Okay, you can leave. Thank you, sir. Thank you. Okay, now finally, I would like to invite Ms. Sarah Benjamin to introduce Dr. Atul Alexander for the last session of the today. Ms. Sarah, the floor is yours. You may introduce Dr. Alexander.
It is my great pleasure to introduce Dr. Atul Alexander, Assistant Professor of Law at the West Bengal National University of Juridical Sciences, Kolkata, and the Faculty Advisor of the International Law Students Association, National University of Juridical Sciences Chapter. Dr. Alexander is an alumnus of Loyola College and the School of Excellence in Law and earned his PhD from the Tamil Nadu Dr. Ambedkar Law University. A recipient of the Junior Research Fellowship, he was ranked first in both his LLB and LLM. He has also earned international diplomas in the law of the seas, magna cum laude, from institutions in Korea and Italy. An accomplished scholar, Dr. Alexander has published in leading journals such as the Asian Journal of International Law, International and Comparative Law Quarterly, and the Chinese Journal of International Law. His works has been cited by distinguished jurists, including the International Court of Justice Judge James Crawford, a recognition that speaks volumes of the quality and global relevance of his research. He has also served as a visiting research scholar at institutions like the Stockholm Center for International Law and the U.S. Naval War College, and has been invited as a panelist at prestigious forums, including the Asian Society of International Law Biennial Conference, the Asian Society of International Law Regional Conference in Beijing, and the European Society of International Law Annual Conference in Stockholm. These global engagements highlight his active contribution to international legal scholarship. His areas of expertise include public international law, diplomatic and consular law, international organizations, and international human rights and refugee law. With his diverse experience, international exposure, and academic achievements, Dr. Alexander brings a truly global perspective to legal education. We are truly honored to have him with us today. To please join me in extending a warm welcome to Dr. Atul Alexander. We look forward to his address and the valuable insights he will share with us. Thank you.
He's not able to.
Okay. I hope I'm audible to all.
You're audible, sir.
Yeah. So firstly, I would like to thank Sarah for the kind introduction given to me. I would also like to thank University of Mysore for the invitation extended to me, and Professor Benjamin for coordinating this event. For coordinating this event. Thank you so much for the invite. I was hearing the previous speakers speak extensively on uh, the specificity of Article 2, Paragraph 4, which is the non-use of force, and Article 51 of UN Charter, which is the right to self-defense. Now, before going into the intricacies of these two provisions, I'll just give a kind of precursor, a kind of why this topic is very important and significant. Firstly, when we talk about any international law issues, we need to be mindful of the fact that international law operates in the background of what we call as politics. So where international politics end, there's a famous saying: international law begins. Right. So law, what is the role of law? Law ensures that states give a kind of proper justification for carrying out certain acts first. Second, it lays down the ground rules as to whether the acts are justified under a certain ground rules. So although political factors ideally or technically influence an act of a state, let's say US under Trump regime attacking, for instance, Iran, would be largely influenced by what we call as political undertones. But law gives a kind of backing, and that is the reason why when Trump recently attacked Iran, he in fact used the term what we call as collective self-defense. So although these powerful states or the Western states in fact violate international law, they don't abstain from using the language of international law to give a kind of legitimacy to that particular act. Now, the topic that we'll be discussing today is on use of force, non-use of force, and self-defense. When we talk about this specific topic, you need to first understand that non-use of force and self-defense can be understood from two angles. One, you can see this doctrine from the perspective of IHL, which is international humanitarian law. The other aspect or other idea of this doctrine emerged in general international or public international law, which is what we call as jus ad bellum. So what we call as right to war is codified in Article 2, Paragraph 4 and Article 51. When we talk about the idea of use of force in international humanitarian law, if there's an armed conflict, then it becomes what we call as right in war. So I'll confine the discussion only to the former aspect, right? Now, initially, before the advent of League of Nations and the United Nations, the system that operated with regard to non-use of force doctrine was what we call as just war theory. So technically, that means one state can attack the other state on religious ground, on the reason given on the basis of religion, right? So law on the use of force was not regulated until the covenant of the League of Nations. So League of Nations, what it did, the 1999, there was this League of Nations that was established, which was a precursor to the United Nations. It tried to what we call as partially ban the use of force, right? So that would mean first a state has to take recourse to a peaceful settlement of dispute. It could be through arbitration, it could be through mediation, or it could be through other means. If that technically fails, then the state could take recourse to war. Now, when you all guys know that the League of Nations failed because of several reasons which are lawful and which are not lawful, we are not going into that. Because the League of Nations failed, the international community of states after Second World War had to create an institution called the United Nations. And the United Nations was very cognizant of the fact that use of force has to be interpreted in such a way that states should not be allowed to use force or wage war unless there are specific circumstances that was fulfilled or complied with. So what did the United Nations do, or the UN Charter do? UN Charter brought a lot of exceptions, right? UN Charter brought an exception called a self-defense. That means a state can use force against other state It is not completely prohibited, but a state can use force in what we call a self-defense. Today, what we are seeing is different manifestation of self-defense. So states are saying there can be self-defense even without a prior attack. States are saying that there can be something called as collective self-defense, wherein one state is assisting other state in carrying out self-defense, like what US is doing in assisting Israel in carrying out self-defense against so-called Iran, right? So there was one exception in self-defense. There is another exception in Chapter 7 resolution, wherein if what happens if the United Nations Security Council comes together and passes a resolution under Chapter 7, the UN members can use force against the state which is in violation of UN Charter. And of course, there are other exceptions which are controversial, like humanitarian intervention, responsibility to protect, invitation by consent, etc., etc. So, for the purpose of our discussion, we will confine it to, as Professor Benjamin had rightly, Professor Banerjee Chakka had rightly pointed out, the idea of self-defense and use of force. So, essentially, I will be discussing Article 2, Paragraph 4, and Article 51 of the United Nations Charter. Now, UN Charter is a very important instrument because if there is a conflict between the UN Charter and other instrument in international law, it is the obligation under the UN Charter that would prevail or supersede. And secondly, UN Charter also binds states which are not parties to the UN Charter. So technically, if a country emerges today and it doesn't sign the UN Charter, still it is bound by the rights and obligations which are enshrined under the UN Charter as per Article 2, Paragraph 6. So today, UN Charter has become what we call a universal document, which has members from all across the globe, right? So Article 2, Paragraph 4 says, as Professor Banerjee has rightly pointed out, that no state shall use force against other state. So technically, this means the provision on the prohibition on the use of force applies to two states. So one state cannot use force against another state. We are not talking about what is happening within the country, right? We are talking about one country using force against the other country. Only then Article 2, Paragraph 4 applies. It doesn't mean that police is using force, let's say in a particular state within India. Article 4 will not technically cover. So Article 2, Paragraph 4, the scope is one state using force against another state. Secondly, it should be against the political independence and the territorial integrity of the state. So if a state attacks another state using, let's say, weapons, missile, bombs, etc., Article 4 of the UN Charter is violated. Of course, I gave you certain exceptions, right? There are certain exceptions where use of force can be legitimately exercised. Thirdly, you need to remember there are exceptions, as I said, self-defense, humanitarian intervention, Chapter 7 resolutions, responsibility to protect, etc. Now, when can a state use force in a rightful way? This is a question that needs to be addressed, right? In self-defense. So in 1970s, there was a scholar by the name Richard Falk who makes an argument, if I'm right, who making this argument saying that Article 51 of the UN Charter has been employed today more than Article 2, Paragraph 4 of UN Charter, because exception today has become the rule. Although Article 51 of the UN Charter, which talks about the exception to the prohibition on the use of force in self-defense, today that has become a rule because Article 51 of UN Charter is exercised the most. And as of course Ambrose sir also pointed out, there are two requirements for a state to lawfully carry out self-defense. One is proportionality, the other is necessity. Now the issue is a state cannot randomly use force in self-defense because the threshold of what is an armed attack is very high. And if one reads a very important case in the International Court of Justice, which is the oil platforms case, it's a very, very important case involving Islamic Republic of Iran and the United States. It's a very interesting case because this case, I'll give you a brief background of this case. There was this Iran-Iraq war that was being waged from 1980 to 1990, right? So Iranian revolution happened in 1970, where the Ayatollah Khomeini regime, then head of Iraq, that is Saddam Hussein. So in this war, what happened? Both Iran and Iraq had placed mines in the region called as the Strait of Hormuz. Strait of Hormuz is one of the active areas in the Middle East, right? And a lot of trade and business happen through this particular zone, that is the Strait of Hormuz. So as usual, the United States was patrolling in this region. Their vessels were patrolling in this region, and these vessels struck one of the mines that was placed as a result of the Iran-Iraq war, and it went shipwrecked. Now, what US did, US went for what we call a self-defense, saying that our ship is destroyed because of the mines that were placed in the Strait of Hormuz. US should not be there in the first place. That is a different question. Now, what did US do? US carried out what we call a self-defense. US attacked the Iranian oil platforms, and it totally destroyed the Iranian oil platforms, offshore oil platforms. So Iran was frustrated by this. Iran took United States to the International Court of Justice, saying that what US did was a wrongful act, and this is not justified use of force, because the use of force that US exercised breached what we call as proportionality and necessity. And the World Court made a very interesting observation. The World Court said, if there is only one attack, or if there is only minor attack, a state cannot use a kind of reaction, self-defense for one attack or a minor attack. So that means a state which is exercising self-defense for the prior armed attack that has been carried out by a state, the aggressor state, the threshold has to be very, very high, right? So randomly a state cannot use self-defense, right? There has to be an armed attack. The armed attack threshold has to be high. It has to be met as per the oil platform judgment. And if that is met, a state can exercise self-defense by exercising what we call as proportionality and necessity, right? This is a point you have to remember. Second controversial issue here is the issue of anticipatory and preemptive self-defense. Today, countries like the United States and the Western states, they are of the view that before an armed attack occurs, a state should be given the option of exercising self-defense. The reason is very simple. Today, there are weapons of mass destruction, right? Like nuclear weapons. So if there is one attack from the nuclear weapon, there is no option for the other state to exercise self-defense. So logically, a state should also be given the right to exercise what we call as anticipatory self-defense. That is a self-defense that happens even prior to an armed attack, right? But the problem with the idea of anticipatory and preemptive self-defense is, firstly, when can you say, how can you measure what is anticipatory and what is preemptive? A state today can randomly say, like India, for instance, can randomly say that Belgium is a threat to us. So we'll carry out self-defense against, anticipatory self-defense against Belgium. This is a hypothetical example that I'm giving. So how do you measure something is anticipatory? How do you gauge whether something is going to happen down the line and you are carrying out self-defense for that, right? And the third important issue in the context of use of force and self-defense, which has been invoked in the context of Iran and United States. You all know that recently Trump attacked the Iranian nuclear facility, right? And I have recently written a piece for the leaflet where I'm arguing that US also intervened. So if a state is intervening on behalf of another state and helping that state to carry out self-defense, this becomes what we call as collective self-defense, right? So in this particular case, Israel carried out initial self-defense, right? Under Benjamin Netanyahu, they carried out initial self-defense. US intervened and was helping Israel in carrying out this self-defense. It became what we call as collective self-defense, right? So collective self-defense, the only requirement is there has to be a request that should be made. So Israel made a request to United States that Iran is enriching nuclear technology, so we have to carry out so-called self-defense against Iran. So collective self-defense is also a requirement. Apart from this, one needs to also remember the fact that if a state is carrying out self-defense, the state has to report the matter to the Security Council. This is a very, very important requirement, although it's a procedural requirement. So the validity or the credibility of this argument of self-defense will be actually assessed by the United Nations Security Council. And that is the reason why when Operation Sindoor happened, when Pulwama attacks happened and India carried out what we call as surgical strikes, India did not report the matter to the Security Council. India used a very vague term called as preemptive surgical strikes. If India had used the term self-defense, anticipatory self-defense against non-state actors, it is problematic because UN can pass a resolution against India. Technically there is a possibility, right? Right. Although there's a possibility of also using veto by any of the states, but technically there could have been a resolution that could be passed against India for the breach of international law in terms of Article 2, Paragraph 4. That is the reason India was very, very clever. in using a very unheard term, that is preemptive surgical strikes. Right? This is not codified either in Article 2, Para 4 or Article 51 of the United Nations Charter. Now, there is another very interesting development that has happened in the area of use of force and self-defense. This is something that is contemporary, and I have been reading and researching on this. Can a state use self-defense against a non-state actor? I think Professor Banerjee Chakka also highlighted some of the critical areas on this particular aspect. Now, I'll go a bit deep and go into the jurisprudence of the International Court of Justice. Now, what happened? First case, as Professor Banerjee had rightly pointed out, is the Nicaragua judgment. In the Nicaragua judgment, the World Court made it very clear the attacks by non-state actor has to be attributed to the state. So individually, a non-state actor cannot be held accountable for the use of force. So that technically means if US is carrying out attacks against Nicaragua using so-called non-state actors or contras, the act of the non-state actor has to be attributed to the United States. So independently, the non-state actors cannot be held responsible for their act that they carry out. It has to be attributed to the state. So this was held in the Nicaragua judgment. Subsequently, there was another case called the Wall Advisory Opinion. So legal consequences of the construction of wall in Palestine, which is also called the Wall Advisory Opinion, the advisory opinion of the World Court in 2004. Now, interestingly, it's a very interesting case where Israel made an argument that we are using force in self-defense against so-called in Palestine. By constructing a wall, we are exercising our right to self-defense. This is a very interesting argument. Now, World Court made a very interesting observation saying that you're technically exercising force against your own state because Israel is an occupying power, right? Israel is an occupying power in Palestine, right? In Gaza, Golan Heights, West Bank, Israel is an occupying power. So it has certain obligations towards the population of the occupying power, right? So it cannot make an argument of self-defense. Technically, it is arguing self-defense against its own state by making that argument. So that argument essentially was rejected by the World Court. And thirdly, the case of DRC versus Uganda, where also the World Court made it very clear that unless it is attributed to a state, in this particular case, it was Uganda, for instance, it cannot be attributed directly to a non-state actor. So ICJ is very clear. ICJ has rejected this argument that a state cannot use force directly against a non-state actor unless it is attributed to a state. And the test of attribution in the Nicaragua case was very high. You would have studied in your PIL class that the test is effective control test. So that means for every actions of the non-state actor, the state should have a control over it. Only then it could be attributed to a state, and the World Court essentially rejected the overall control test, right? Now the position becomes very interesting when we talk about UNSC resolutions. So ICJ has taken this view, but after 9/11, after the Twin Tower attacks, United Nations Security Council passed number of resolutions, 1363, 1368, 1373, etc., where it said a state can use all necessary means to eradicate non-state actors. So essentially, the United Nations Security Council is saying that you can use force against non-state actors. And this is a reason why non-state actors actually disappeared, at least till 2010, after this particular resolutions that were passed in the UNSC. Now, I can give you an example of LTT. You might be knowing about this non-state actor called as LTT, right? This non-state actor was operating in Sri Lanka. And because of the UNSC resolution, it did not gain adequate support from the international community. And also, their accounts were frozen. Freezing of assets. You have to freeze the assets of non-state actors so that they don't carry out unlawful acts. So on the one hand, you have the Security Council, which says that you can use force against non-state actor, so-called belligerents for self-defense, using self-defense. On the other hand, the ICJ is saying that you can't use force against a non-state actor unless it is attributed to a state. So this is a very controversial issue today in international law as to whether a state can use force in self-defense against a non-state actor, whether this is justified or not. Now, in recent times, there is another very important argument that has emerged, which is called as unable or unwilling test. All right, unable or unwilling test. Right, that means if a state is not able to control the non-state actor within its territory, another state can use force directly against the non-state actor. I can give you one example of this. You have this group called as ISIS, right, in Syria. ISIS is a very powerful non-state actor in Syria, ISIS, right? And ISIS Syrian government Syrian government is not able to tackle the menace of ISIS. So actually, Syria is unable, right? Unable to tackle or unable to destroy this so-called non-state actor called as ISIS. So a state can say that because Syria is unable to destroy this so-called ISIS, the state can legitimately use force against ISIS directly. And this test is called as unable or unwilling test, right? Unable or unwilling test. And this is usually interpreted by the aggressor state. So let's say US wants to intervene in a country, it might make an argument that the other state is unable or unwilling to curb terrorism in its territory, and we are interfering and we are using force against the other state. But this can be problematic, right? Because a lot of third world scholars are arguing, including India, that this might be subject to abuse. Tomorrow, United States can say that India houses terrorists and we are attacking India based on the information that we have with us. So this can be randomly abused by states because we are going beyond the UNSC mandate, right? So what I can arguably say, or what the argument that I could make is all these justifications are legitimate, but legitimacy doesn't mean that something is lawful, right? Understand the difference. Arguments could be legitimate, but that doesn't mean that the arguments which are made would be lawful. Now, to cover a bit more area in the field of non-use of force. Now, scholars are saying that there is no distinction between use of force and aggression. There is actually a difference between aggression and use of force. Now, the difference is very simple. In the Nicaragua case, the World Code made this difference so apparent. So, a minor, what we call as an aggravated form of use of force is what we call as aggression. See, making this distinction is very, very important. Making the distinction between use of force and aggression is very important because aggression today doesn't have any exception. Use of force under Article 2, Paragraph 4 has certain exceptions, right? Self-defense, Chapter 7 resolution, humanitarian intervention, responsibility to protect, etc., etc. But aggression, which is an aggravated form of use of force in terms of gravity, doesn't have any exception as per the UNGA Resolution 3314. So one could make an argument, for argument's sake, that this is something that I've also written on, that US, when it attacks countries like Iran, right, unilaterally, it is not only carrying out or violating the principle of use of force, it is also committing act of aggression wherein there cannot be any justification. Lawful or unlawful, lawful or legitimate, there cannot be any justification for a state to use force and commit aggression, because aggression is a peremptory norm. Aggression is a just cogence norm or peremptory norms. What are peremptory norms? Peremptory norms are norms which cannot be violated by any state, and there's no exception to that particular norm, and states cannot derogate from this norm. So one could make this argument saying that a state resorting to use of force is committing an act of aggression, and self-defense cannot be a proper justification or defense that could be carried out by states, or defense that could be invoked. Now, I'm giving you a simple case study here. Let's take the case study of Israel and Palestine. Now, Israel is saying, Israel's argument is very clear. Israel is saying that the laws of the public international law or UN Charter principles doesn't apply to Palestine. So essentially, just ad bellum doesn't apply in case of Israel-Palestine because it's a situation of armed conflict. The applicable law should be IHL, not Article 2, Paragraph 4 or Article 51. This is the argument given by Israeli scholars, right? Like you have a scholar by the name Yuval Shani. So a lot of Israeli scholars make an argument that Article 2, Paragraph 4, Article 51, all these arguments do not apply to us because we are in a situation of war with Palestine. So the applicable rules should be just in bello, that is right in war, which is international humanitarian. On the other hand, Palestine is making an argument, how can Israel exercise self-defense and commit genocide? Is there a right given to a state to use force in self-defense, and in doing so, whether they can commit genocide? And this is where ICJ's judgment again comes in handy. So in the year 2022, if I'm right, there was a case involving Ukraine and Russia in the International Court of Justice. It's a very important case. Ukraine took Russia to the ICJ, making an argument that Ukraine is abusing the interpretation of the Genocide Convention by intervening in a region called as Donetsk, right, in the territory of Ukraine. Russia is making an argument that we intervened to prevent genocide, right, to prevent genocide. The World Court said a state can exercise self-defense, but it should be within the scope of international law, which should be in the terms of permitted under international law. So when Israel commits self-defense and it commits acts of genocide, I'm not saying this. There is a very interesting report that came up yesterday by the Palestinian Center for Human Rights. This is an NGO. They came up with a very detailed 200-page report saying that whatever is happening in this region is genocide. Now, a state cannot use self-defense to commit genocide, as simple as that. By Israel is arguing it's not a case of application of general international law, but it's a question of international humanitarian law. Right. Now, coming to the second case study called as Operation Sindoor. Recently, India carried out attacks against Pakistan, right, in its territory. But again, India did not use the language of self-defense. India did not use the language of self-defense. India instead carried out direct attacks against so-called non-state actors. India is very clever in doing that because India knows that if it uses self-defense, use of force, it will be reported to the Security Council. Now, one needs to assess, how do you assess proportionality and necessity when you are using force in self-defense against a non-state actor? It is very difficult to assess, right? And can a state use self-defense against non-state actors in terms of preemptive self-defense or anticipatory self-defense? This is something that is evolving today, right? Can a state, I'll repeat this, can a state use self-defense against non-state actor in terms of anticipatory self-defense or preemptive self-defense? Because the nature of the attacks that the non-state actors carry out is very sporadic, right? So today a non-state actor will attack a state. Then after a period of 5 years, they'll carry out another attack. So the attacks by non-state actors are very, very sporadic, right? So logically, it makes sense to use force against non-state actors because their attacks are largely unpredictable, right? So it makes a lot of sense for a state to use anticipatory or preemptive self-defense against the non-state actors because of the nature of the attacks that they carry out, which can be very, very uncertain. And if the same thing is deployed against state, it can be abused by state by taking a very, very what we call as the liberal approach to self-defense. Now, we saw a lot of interpretation taken with regard to Article 2, Para 4 and 51 of the UN Charter, right? There are a lot of confusion. For instance, what is proportionality? What is anticipatory self-defense? Whether the issue has to be reported to the Security Council? How does humanitarian intervention come into the picture? Responsibility to protect. And this is where there's a scholar who argues in a piece in Opinio Juris. Opinio Juris is one of the leading blogs in international law. I think you guys have to read, at least the students who are present here should develop the habit of reading blogs so that you stay updated in the subject, right? The scholar makes an argument that the International Law Commission has to come up with the draft guidelines on use of force and self-defense, right? Because there is a lot of outstanding issues which are unresolved, right? So what the ILC could do, the International Law Commission, because the International Law Commission does the task of codification and progressive development, right? That is the mandate of the International Law Commission. So International Law Commission can undertake a work under a special rapporteur and they can undertake a study, and this could be brought in the agenda of the ILC, and they could codify laws on use of force and self-defense, giving some clarity. As of now, Article 2, Paragraph 4, as Banerjee Chakka had rightly pointed out, does not cover certain issues like cyber attacks. Cyber warfare is not covered in Article 2, Paragraph 4 in terms of use of force. And this is the reason why the Talon manual, authored by Professor Skimmett, as Banerjee had rightly pointed out, points to a test called as consequences test, right? So you need to look into the consequences of the act to determine whether a state can exercise self-defense and use force, right? But unfortunately, these might be legitimate, but these are not lawful under international law because this doesn't constitute what we call a subsequent practice under the UN Charter, right? So the International Law Commission, to give clarity, can codify the laws on use of force and self-defense. This would mitigate a lot of disparity in terms of the interpretations taken by states, because today Israel is taking one interpretation, India is taking one interpretation, US is taking one interpretation, ICJ is taking one interpretation, UNSC is taking one interpretation, states are taking another interpretation, or scholars might take some other interpretation. So ILC can contribute in codifying the laws. The second thing that essentially could be done is Article 2, Paragraph 4 could be extended beyond what we call as armed attack. So today we talk about crimes of ecocide, right? Using force against environment. Whether Article 2, Paragraph 4 of UN Charter is sufficient to cover situations when environment is being targeted or attacked, or whether Article 2, Paragraph 4 is confined to only human-made attacks, in the sense when only humans are affected, when there is human casualty, or whether this Article 4 interpretation, whether it could be extended to what we call as environment in terms of acts of ecocide. Currently, ecocide is covered under international humanitarian law. So why not it be covered under Article 2, Paragraph 4? So you would also cover situations of peace where Article 2, Paragraph 4 could be applied in situations of attacks on environment. So you need to go beyond what we call as instrumental based approach to what we call as consequential based approach to interpret Article 2, Paragraph 4. And that would mean that you are in tune with the realities of this particular developments that are happening in the context of use of force and self-defense. I think with this, I would like to conclude. Again, I would like to take questions if there are questions from the participants. And I would again like to thank Professor Benjamin and the organizers, the Vice Chancellor of the university, for the kind invitation extended to me. Thank you so much. It was a pleasure and privilege. Yeah.
Thank you, Dr. Alexander, for your insightful explanation on the various aspects of international law and international humanitarian law, and you have cited some case laws also. So now we reach to the conclusion. I would like to request Ms. Sarah Benjamin to deliver a vote of thanks, and our program ends.
If there are questions, I could take those questions. I think there are questions that are posted in the chat.
Is there a difference between interpretation of writing in the court? Yeah. I think there is a question for you. Is there any difference in the interpretation? Could you see?
Yeah, just a
Yes.
Yeah, I'm not able to see, I think. It talks about that. Is there any difference of interpretation varying on court in region and regions? So it means about the countries. And what's the difference between Article 51 of the UN Charter and Article 5 of the NATO treaty?
Yeah, so today what is happening, there are multiple interpretations given to Article 51 of UN Charter because of the emergence of what we call regionalism. So because international law today has become very regional, right? So there are regional organizations called like NATO, that is the North Atlantic Treaty the organization. They have their own constituent instrument called as the NATO Charter, right? They give a kind of parallel interpretation to the UN Charter because UN Charter is not adequately addressing the issue of self-defense and use of force. So, of course, this is a reality today, but also very interestingly, what the question also points out is there are courts, domestic courts. I remember reading a judgment given by the Pakistani court on the use of force and self-defense when US had intervened in Afghanistan, right? So that is a very important development that has happened where courts, domestic courts have also started to interpret the scope of Article 2, Para 4 and Article 51. So because that makes it necessary for the International Law Commission to come into the picture and create a kind of draft guidelines so that everything is systematized and there is no confusion amongst the states as to what is the scope and ambit of Article 51 and Article 2, Paragraph 4. And there's one more question that I could see in the chat box. Maybe I could read that out. That could be done. There was one more question. This is a very interesting question. What is the relevance of international organization in maintaining international law as they are not they're internationally binding on all states? What do you think? Yeah, this is a very important and relevant question. Now, international organizations today play a very important role because they have what we call as international legal personality, right? And this was highlighted by the International Court of Justice in what we call as the reparations case. Right? Reparations case is one of the earliest judgment of the International Court of Justice, where it was highlighted that international legal personality is attributed to what we call as international organizations. And secondly, states undertake their activities or actions through the international organization, right? So they pass on the responsibility to the international organization or IO, and the IOs carry out the opinion of the states, right? And organizations kind of become a vehicle for the actions of the state. So today, organizations play a very important role in the maintenance of international peace and security. And this is a mandate given under Article 24 of UN Charter, because UNSC, United Nations Security Council, can determine anything as to do with peace. So today, climate change will come under the ambit of peace and security. United Nations can pass a resolution on pandemic treaty. It can pass a resolution on climate change. So international organization, because of its evolution and because of its complexities, are dealing with multiple issues. Initially, it was only to maintain peace. Today, it is dealing with issues like health. It is dealing with issues on economic affairs, economic matters, etc., etc. So IOs play a very, very important role, because states' aspirations or states' activities are reflected through the activities of IO, right? And IOs are equally responsible if they also commit a wrongful act. Let's say United Nations peacekeepers, who are also part of the United Nations framework, they go and commit a wrongful act. The acts of the UN peacekeepers are attributed to the IOs, right? Because they have what we call as international legal personality. So IOs, international organization, play a very important role. And today it has become relevant because this is a platform where you can go for what we call as international cooperation, right? And IOs can play an instrumental role in that, right? In maintaining international peace and security. I can see more questions. With the permission of the organizers, if there is time, I could take these questions. I think 3-4 questions.
We are running out of the time.
Okay,
so-
then it's okay.
Yes.
You have any questions? You can mail me your doubts. I'll be happy to clarify your on your questions.
You may
Thank
share email address. So in the chat box.
I'll put it in the group, in the chat box. Right? Okay.
Ms. Sarah, you may proceed.
Good evening to everyone present here. It is my privilege and honor to extend the vote of thanks on behalf of the Department of Studies and Law, University of Mysore, at the successful conclusion of this international webinar on the right of self-defense under international law, principles, practice, and prospects. At the outset, I wish to record our deepest gratitude to our chief patron, Professor Dr. Loknath N.K., Honorable Vice Chancellor of the University of Mysore, and our patron, Srimati M.K. Savita, Registrar, University of Mysore. Their unwavering encouragement and support have been the guiding force behind the success of this academic endeavor. A heartfelt thanks to our chief guest, Professor Dr. Manoj Kumar Sinha, Honorable Vice Chancellor, Dharmashastra National Law University, Jabalpur, for gracing this occasion and delivering an inspiring address on the vital issues surrounding the principle of self-defense under international law. We are equally grateful to our guest of honor, Professor Dr. David Ambrose, former professor and head, Department of Legal Studies, University of Madras, for his enriching reflections that added great depth to today's discussions. I also extend our sincere appreciation to our eminent speakers, Professor Dr. Srinivasulu N.S., Professor of Law, National University of Juridical Sciences, Kolkata, Professor Dr. Kenneth Wayne Mutuma, Professor of Law, Mount Kenya School of Law, Professor Dr. Mirza Asmar Beg, Professor Aligarh Muslim University, Professor Dr. Banerjee Chakka, Dean, Vellore Institute of Technology, Andhra Pradesh School of Law, and Dr. Atul Alexander, Assistant Professor, West Bengal National University of Juridical Sciences, Kolkata. Your scholarly deliberations and thought provoking insights have provided us with a comprehensive understanding of the challenges, practices, and prospects of self defense under the international law. A special note of appreciation goes to our organizing secretary, Professor Dr. M.S. Benjamin, Dean, Faculty of Law, for his constant guidance and leadership, and to our coordinator, Mr. Syed Kudrat Hashmi, PhD scholar, for his tireless effort in planning and executing this webinar with precision. Finally, we extend a warm thanks to the technical and media team working behind the scenes, whose dedicated efforts ensure the seamless conduct of this virtual event. To all our participants,